Dear fellow judges, members of what I like to call the European judicial community, both in the room, my fellow colleagues of the court, both current colleagues and former colleagues, dear participants further afield around the world and in Europe. It is a great pleasure for me to be here with you for the 7th Regional Rule of Law Forum for Southeast Europe, which is being held online, like many of these events over these past few months due to the health crisis. It is important for us, and we felt it was very important to take part, to bring together judges of the court, Supreme and Constitutional Courts, presidents of judicial councils, directors of judicial training academies, and other prominent experts and stakeholders, which I believe are with us across 7 countries of the region. Despite the current health crisis, the organizers have managed, remarkably, to maintain this forum as a hybrid meeting using information technology to allow the dialogue and conversation to continue within the judicial community on topical issues for the protection of human rights. I have said before in public conferences over the past few months, we are faced with an extremely difficult situation for all of us, but we must attempt to and try as much as we can to continue to do our work, to understand that in the face of this crisis, the protection of human rights and the need to contain and uphold the safeguards of human rights and fundamental freedoms continues unabated. One of the expected outcomes, however, of this crisis is that we have all been forced to learn to communicate with each other in novel ways. This has occurred on a personal level with family and friends, but as well as today on a professional level. We are becoming more at ease with virtual meetings and seminars, and as a result, a number of restricted conferences and seminars have been opened up to greater numbers, as was mentioned by Mr. Militic just now. And I think that is a good and positive outcome of the crisis, if we can call consequences of the crisis at all positive. I also think it's very apt that the chosen subject for this forum is the pandemic itself and its relationship with the European Convention on Human Rights. This is an incredibly important topic. I have already participated in 3 online events on the effect of the pandemic on human rights. The first one in June was a video conference organized by the Greek chairmanship of the Committee of Ministers as a lessons learned discussion within the organization. The second in July was a dialogue and sharing of experiences with Judge Cybertfor and Judge Bortsen of the court with the 3 regional human rights courts, the European Court of Human Rights, of course, the African Court of Human and People's Rights, and the Inter-American Court of Human Rights on the impact of COVID-19 on human rights. The third event which I took part in was also in July, which was organized by our Superior Courts Network, which we termed on adapting justice systems to the COVID-19 pandemic and the potential impact on the right to a fair trial. Sharing national experience and good practice in responding to COVID-19 is essential for encouraging a more harmonized approach within the Council of Europe legal space. Ladies and gentlemen, the pandemic is a health crisis with serious human, social, and economic consequences. To combat the pandemic, member states have taken a number of measures which have restricted human rights, sometimes introduced under a state of emergency, sometimes accompanied by a derogation or derogations from the obligations of the European Convention. Accordingly, the pandemic also poses challenges for human rights and the rule of law. The panel discussions this morning and this afternoon were focused on particular convention rights affected not just by the pandemic, but by the state's response to the pandemic. It is crucial to maintain a framework of upholding human rights and the rule of law while responding to the pandemic. A number of key human rights are likely to be affected by measures taken to combat the pandemic, such as the right of freedom of assembly, of freedom of movement, right to privacy, freedom of expression, and potentially other issues related to the ones I just mentioned, and I name, for example, data protection and surveillance. I would like to congratulate the organizers on their guide on the convention in the time of the pandemic, which provides comprehensive research materials for practitioners in courts. I have decided to concentrate the rest of my intervention on a principle of law which, and I quote from our case law, is inherent in all the articles of the convention, and also, as we've said, the court inspires the whole convention. This principle, the rule of law, I have called the Lodestar of the convention, the shining star that guides us in our work. It constitutes, in other words, the legal and moral foundation of the work of the court, with the fundamental principles of democracy and human dignity. As I will develop later, there are certain key legal rules or principles which all derive from the rule of law, which we must bear in mind when assessing whether measures taken to respond to the pandemic have potentially conflicted with human rights norms. But allow me, before embarking on the normative part of my contribution, allow me to outline how the court itself, and I think this is interesting also for our counterparts and colleagues in the region, how we, the court ourselves, have been adapting with our working methods to this unprecedented situation. I then want to continue by making a general point about the nature and scope of the pandemic and its consequences on human rights before I conclude by elaborating on the way in which the pandemic impacts the rule of law. So to my first part. Restrictions on freedom of movement of assembly have inevitably had an impact on the work of all courts, including the European Court of Human Rights. Yet access to justice during the pandemic is also an important aspect of the right to a fair hearing under Article 6, which is a fundamental component of the rule of law. Article 6 foresees exceptions to the public nature of court proceedings on different grounds, including in the interest of public order in a democracy, and to the extent strictly necessary in the opinion of the court in special circumstances where publicity would prejudice the interests of justice. Now, this has been an important challenge in the era of the pandemic, where measures have had to be taken by courts, our court as well, to prevent the spread of the pandemic, and thus being a justification for holding online hearings with the exclusion of the public, but to the extent that the online hearings have maintained the public character of those hearings secured by information technology. And we'll say a few words about what we have done in that regard in a moment. The functioning of national judicial systems has also been severely disrupted. We know that. That is clear. I would like to mention here the Declaration on Lessons Learned and Challenges Faced by the Judiciary during and after the COVID-19 pandemic, which was adopted by the European Commission for the Efficiency of Justice, the CEPEJ, and sets out 7 guiding principles. As far as the judiciary is concerned, it underlines that the continuous functioning of the judiciary and of the services provided by justice professionals needs to be ensured based on European standards. Trust in justice must continue even at a time of crisis. As to the court itself, several exceptional measures were taken by the court during the French lockdown, the national lockdown, which was a period from 16 March to 10 May of this year. Most importantly, my predecessor, the then president of the court, Alexander Sicilianos, extended the 6-month time limit for lodging of an application based on force majeure reasoning for 3 months until 15 June 2020 inclusive. The time limits which had been allotted in pending proceedings extended for a month period from 16 March were also extended for a further 2-month period from 16 April. The European Court has been able to fulfill its public service mission during the French lockdown period by ensuring the continuity of its core activities, including the handling of urgent cases and receiving and allocating applications to the relevant judicial formations. The Grand Chamber, chambers, committees, and single judges continue to examine cases by way of a written procedure, We were, most of us and all of the judges during the French lockdown, either in France ourselves or some of us in our home countries, dealing with cases during a written email procedure, which of course posed challenges, but I must say, and I'm extremely proud of my colleagues and all the registry staff for continuing to function as a court and dealing with cases as expeditiously as possible during that very difficult time. More than 5,400 applications were processed during this period. As a result of this activity, the total stock of pending cases has remained stable during these difficult months. As an international court, a significant achievement was the organization of grand chamber hearings, which took place by video conference and which the outside world was able to watch online. This was a major technical challenge for us. We held 3 online hearings in June and 1 just this week, and we will hold another one next week. In this way, the court has been able to continue to carry out its mission. We were also able to ensure the public nature of these hearings through their webcasting. I know that we have had very many viewers for some of these hearings, over 4,000 views for one of them, and we have received very positive feedback, questions being posed to us by judges and courts all over Europe, particularly on how we have been functioning during this exceptional situation. So now let me turn to my second part. I would suggest, and I say this profoundly, that the pandemic has underlined the importance of economic, social, cultural rights as well as core civil and political ones. It has reminded us of the need for solidarity in our communities, of the importance of social safety nets and a well-resourced healthcare system. We have realized that the younger generation needs stable and secure employment and opportunities for the future. These are all general elements we all see. We have all appreciated the cleaner air and reduction in pollution in our cities during the lockdown, which unfortunately was potentially a temporary issue. The pandemic has brought peoples back to first principles and to the realization of the importance of family life. But it is also shown, as we have seen, shown a spotlight on issues like domestic violence. While the pandemic has triggered a public health crisis, it also clearly represents a great challenge for human rights and the rule of law. It has put pressure on Council of Europe member states to fulfill their positive obligations to protect life and health. These obligations arise primarily under Articles 2, the right to life, 3, protection from inhumane and degrading treatment, and Article 8, the right to respect for private and family life. There exists, consequently, the risk of the pandemic being used as a pretext for abusing public power, imposing measures on the populace which, although intuitively persuasive, in the face of an unprecedented threat to human life and well-being, is upon a closer look, potentially, a disproportionate overreach which threatens the fundamentals of democratic life, societies governed by the rule of law and the protection of human rights. On this, as in so many facets of our lives, balance is key. Now, it is here that I want, in my final part, to focus on the normative aspect of the issue that I have just raised. While there is no abstract definition of the rule of law in the court's case law, the court has developed various substantive guarantees which may be inferred from this notion. These include the principle of legality or foreseeability, the principle of legal certainty, the principle of equality of individuals before the law, the principle that the executive cannot have unfettered powers whenever a right or freedom is at stake, the principle of the possibility of a remedy before an independent and impartial court, and the right to a fair trial. Some of these principles are closely interrelated and can be included in the categories of legality and due process. They all aim at protecting the individual from arbitrariness, especially in the relations between the individual and the state. All of these various elements will be dealt with by my colleagues on the court, both former and current judges, in their interventions here today. Before finally extrapolating and presenting you 4 key principles, which I would say are sub-principles under the overarching rubric of the rule of law, let me just say 2 more general remarks. It is often said that the rule of law has become a cliche, has become a word which is often used in an overly vague and abstract fashion. Because of its vague content, we are often dealing with a situation where we are talking across each other's or in an abstract fashion, even within the judicial community. Let me make clear my own view of this, that we should not underestimate the nature, scope, and origins of the rule of law principle. This is a foundational constitutional principle in the European legal order. It's a fundamental constitutional pillar of the convention system, but it is challenging to find and extrapolate the substance of the rule of law in individual cases. That is a challenge that we all need to engage with, but it is not an answer, in my view, to try to downplay the importance of the rule of law in the current climate. On the contrary, we have to engage with it and make it become even more alive and enforceable within our respective legal systems. Now, as I mentioned, I want to conclude by providing to, as we are dealing here amongst judges, providing you with 4 key principles or key elements which derive from the principle of the rule of law as it is manifested in the case law of the court. Firstly, the public interest, whilst undoubtedly important, cannot be an absolute trump card for national authorities in the fight against the pandemic. The convention requires proportionality, a balance to be struck between the public interest and the autonomy of the person. The responsibility for striking that balance is at the outset for the national authorities. In short, the convention requires all national authorities, the legislative, executive, and judicial branches, to engage with the principle of proportionality in good faith. As I have repeatedly stated after the beginning of my mandate, in all of my public lectures, the convention does not tolerate extremes. Secondly, the principle of legality, based on the primordial principle of the rule of law that, as I've mentioned, permeates the convention, will become ever salient when lockdowns, restrictions on freedom of movement, and other such measures have been imposed. The principle of legality requires that measures taken at national level have a legal basis, are accessible and foreseeable. This precludes vague and overbroad rules that run the risk of unpredictability and arbitrariness in their enforcement. Thirdly, rules adopted at national level as a basis for pandemic-related measures restricting individual rights must not afford excessive discretion to the executive. During states of emergency, countries often introduce shifts in the distribution of powers to deal with the crisis at hand. In a true democracy, the executive must not be the sole arbiter of what rules are applicable. The democratically elected legislator must be reactive and up to the task of engaging with the difficult balancing of interests required in this field. Built-in review mechanisms such as parliamentary and judicial scrutiny are therefore required. Shifts in the redistribution of power should be proportionate and temporary. These are elements also mentioned in recent reports by the Venice Commission. Fourthly, the adoption of emergency laws or declarations deviating in general from convention guarantees must be strictly tailored to meet the exigencies of the situation. As the court has stated, even in a state of emergency, this is a recent judgment of the court, the contracting states must bear in mind that any measures taken should seek to protect the democratic order from the threats to it, and every effort must be made to safeguard the values of a democratic society such as pluralism, tolerance, and broad-mindedness. As I mentioned, the Venice Commission has identified a list of principles governing the state of emergency that the Commission considers should be applied in order to ensure compliance with Council of Europe standards. I, of course, at this point take no position on those principles, but I mention them as a source and relevant inspiration for our conversation. All emergency measures must have a sufficient legal basis. Emergency laws should not become the new normal. Between March and April 2020, 10 states notified the Council of Europe of their intention to derogate from their obligations under the European Convention on Human Rights to respond to the pandemic, and my colleague Judge Vahabovic will deal with that issue later today. Dear judges, dear participants and colleagues, allow me now to conclude. We have seen that the challenge for member states is to balance, on the one hand, a necessary response to threats to public health, and on the other, proportionate measures which uphold fundamental freedoms and democratic decision-making. Finding the right balance is key, but may not always be easy. As domestic judges, you will be called upon to assess the measures taken by your state in response to the pandemic and their effect on fundamental rights and freedoms. They may be emergency measures or measures taken within a state of emergency. They may have been taken within the context of a derogation of one or more articles to the European Convention. In attempting to respond quickly to the changing dynamics of the sanitary situation, the core rule of law principles I have outlined earlier may have been overlooked, disregarded, or even flouted. The pressure on governments to act and to act quickly is great. As judges at the domestic level, your role when challenges are brought to the courts will be to assess the facts of each case and to apply the core rule of law principles as based on the Strasbourg Court's case law. As judges at the European level, as part of the European judicial community, our role will be to clarify those principles and to assess whether your domestic scrutiny has been in conformity with what the Convention requires. The European Convention on Human Rights continues to set limits, thereby ensuring that respect for democracy, human rights, and the rule of law, the foundational pillars of the Council of Europe, remains intact even as we fight the pandemic together. I hope that today will bring us a source of inspiration with continued dialogue, with a continued conversation, and I very much look forward to hearing the interventions of other speakers today. Thank you very much indeed.